Now, a plumber has won a legal battle over workers' rights. It's a Supreme Court ruling that could have big ramifications for freelance workers anywhere. It said that Gary Smith, who had solely worked for Pimlico Plumbers for 6 years, was entitled to employment rights like holiday and sick pay. One of the judges, Lord Wilson, read the ruling.
Although the contract did provide him with elements of operational and financial independence, its terms enabled the company to impose fierce conditions on when and how much it paid to him, which were described at one point as his wages, and to restrict his ability to compete with it for plumbing work following any termination of their relationship.
Well, employment lawyer Gillian Merchant's here. Hello.
Hello.
Now, this is complicated because we have a world where some people are completely freelance and they are brought in occasionally. We have a world where some people are personal service companies and they then are either working almost full-time for companies or sometimes, and we have employees and we have short-term contracts. How significant is this ruling?
I mean, I think it's a good judgment. It's an important judgment, mainly because for too long, employers like Pimlico Plumbers have been using these bogus self-employment type contracts to deny workers their basic employment rights. And that was essentially what this case was. Mr. Smith brought a case for unlawful deduction from wages, for discrimination and for holiday pay. And if he had been a self-employed contractor, he wouldn't have had those rights to bring those cases. And it's that issue that's gone all the way to the Supreme Court and has been resolved in his favour.
What does it mean? Because the reason a company doesn't want to have you as staff often is that if you become staff, you're an extra cost to them. You've got to pay employers NIC, you've got to pay perhaps into a Nest pension scheme. You've also got to come up with holiday pay, etc., etc., etc. What does this mean for people in the gig economy? Will this change anything?
I mean, I think that is exactly the issue, and the judgment does address that, where it says that essentially Pimlico Plumbers wanted it both ways. They wanted to present people like Mr. Smith as part of a team, part of the workforce, part of their employment. They were
in the uniform.
They had to wear a uniform, and they wanted to strictly control what he did and how he did it. But at the same time, they didn't want to offer him any of the employment rights that would come with that. And the judgment, describes the contract as puzzling, which I think, coming from a Supreme Court justice, really says it all in terms of where this employer was going. But I think obviously all cases are pretty fact specific, and the specific issue with this case was whether or not he was providing his services personally or whether or not he could substitute in someone else. And really that was the main issue that the Supreme Court resolved in his favour, was that he didn't have a free right of substitution, because basically one of the tests for being a worker, which was what the case was about, is if you provide the services personally or not.
It's becoming complicated too, isn't it? Because the Inland Revenue is going back through people who've been contracted themselves to companies through personal service companies. They're saying, well, actually, you were employees because you worked 5 days a week for somebody. You might have set up a company. That saved you tax. It saved the employing company tax too, because, as I said, they didn't have employers NIC. But the revenue, they're getting pretty strict on these things now, aren't they? They're chasing people going back in time.
I mean, I think it's another thing that's come out of this in these types of contracts, which essentially have been set up so that employers, with contracts that are not employment contracts, then the employers, for the widest possible term, don't have the same obligations, and whether that be to the worker or to the Inland Revenue. And I think when the Inland Revenue start to go back and look at all these things, then yeah, there probably is going to be a case for tax that should have been paid that wasn't paid.
For everyone listening, what is the definition for self-employed now?
Self-employed is basically someone who works on a contract, who has the right of substitution. They can send anyone that they are entitled to send in their place. They don't have any responsibilities in terms of towards that employer. They only have to work under a very specific contract for very specific work. They're not paid through PAYE, is quite a significant one. And essentially that they can choose as and when they work. There's no set rules in terms of that kind of thing, as long as the contract is fulfilled.
Where do you see this all going in the future? What are the next hurdles that we're going to see happening.
I mean, I think there's a lot of talk around like whether or not the law needs to be changed to clarify the definitions of employee versus worker versus self-employed. And as someone who represents employees,
What's the difference between an employee, worker and self-employed?
so an employee is someone who has a full benefit of employment rights. They can claim unfair dismissal. They're entitled to the national minimum wage. They can they're entitled to holiday pay. A worker is someone like Mr. Smith has been deemed to be, who provides provides services personally, but is not an employee. So he's entitled to the national minimum wage, but he can't bring a claim for unfair dismissal. So there is quite a lot of debate going around in terms of whether or not these matters need to be clarified in terms of how they're set out in the law. But whether it actually needs to be or not, I think is a moot point, because the laws are already there. The point is that it's been companies which have been exploiting them for their own financial gain.
Employment lawyer Gillian Merchant, thank you very much indeed.